for delivery of judgment.
Item number?
Item number 12, 13, and 14.
MSc appeal number?
MEGAP 12 of 2025 with COB-FA 2 of 2025 and MEGAP 16 of 2025.
MSc appeal number 12 of 2025 dismissed. Cross objection allowed. Award is modified to limited extent.
We shall proceed to daily cost list. Item number 1.
Appeal partly allowed. Award is modified.
I seek your lordship indulgence in mentioning item number 14 of hearing list.
Yes. Where is the cause list?
Item number 14 of hearing list, WPC number 63 of 2023. Your lordship, this may come up on next week, Thursday, 2nd of July.
Mr. Ralte, learned counsel for the petitioner. Any objection from the other side? You
State,
inform the other
I
side?
inform them.
With consent from the other side, press for listing the matter on next Thursday. Where allowed, press shall list the matter on Thursday.
And my lord, item number 15, this may come up after vacation, after the ensuing vacation.
Mr. Ralte, learned counsel for the petitioner with consent from the other side, press for listing the matter after vacation. Where allowed.
Deeply obliged.
Lordship, if I may be allowed to make a mention regarding item number 13 of part 2.
Partial list. Part.
With consent from the other party, Lordship, if this matter may come up on 14 July.
RFF 49?
Lordship, yes.
Ms. Johnson, learned counsel for the appellant with consent from the other side, press for listing the matter on 14th of July.
14 July.
Where allowed.
Deeply obliged.
I seek your lordship indulgence in mentioning part 2, item number 6. This case is taken by my senior Miss Mariel Kiente. With the consent of the other party, may this matter be taken after 2 weeks?
After 2 weeks.
Yes, your lordship.
Mr.
Daniel Russell.
Learned counsel appearing on behalf of
Miss
the learned additional PP, Miss
Mariel Kiente.
learned additional PP with consent from the other side, press for listing the matter after
2 weeks.
2 weeks.
Yes, your lordship.
Where allowed.
Right, your lordship.
May I seek your lordship's indulgence in mentioning an unlisted item, my lord. The item number is WPC 80 of 2026. I am praying on behalf of Ms. Lalrin Omitsaktswak. It is seen that the petitioner is on the verge of is about to be terminated from his service. He is a BSF service, and his service will be terminated on 30th of this month. So if this matter may kindly be listed on Monday, which is
Monday?
29th. Yes, my lord.
Monday?
Yes, my lord.
Okay.
Item number 1.
In item number 1, I have been given some. I've been given instructions to file an affidavit impleading the forest department and to also explain the draft award that has suddenly rise to some amount. My lord, I'll have to seek some more time since forest department, whether they will be impleaded as a party or not, my lord, I have to take instructions from the department. And since the PCCF is out of station at this moment, they cannot come to a decision whether they will be needing to be a party in this case or not, my lord.
Heard Mr. Ralte, learned counsel for the petitioner. Ms. Pembuel, learned additional AG for the state respondent. Ms. Pembuel submits that though she was directed by this court by the order dated 8/6/2026 to file an impleadment petition impleading the forest department and also to make an inquiry and give reason as to why the compensation amount of rupees 60 crore 81 lakhs 95,531 in draft award number 1 of 2022 has now been suddenly raised to 147 crore 85 lakhs 64,184.04 in the draft award number 1 of 2026 after 3.5 years. And she has not received instruction from the forest department,
Yes, my lord.
and she pressed for granting her some more time to receive instruction and to apprise this court about the reason as to why the compensation amount inflated in the draft award number 1 of 2026. Fair allowed, this is a list the matter. After vacation,
After vacation, my lord.
My lord, can we have a fixed date on 21st of July?
21st of July. Okay, this is a list the matter on 21st of July.
Much obliged.
Item number 2.
My lord, if I may be kindly given another 2 weeks' time to file my rejoinder affidavit.
Okay. Heard Miss, your
Let
name
time flow
please.
if
Learned counsel for the petitioner and Mr.
Anand Huma on behalf of my senior Valentina for R5 and R6.
for respondent number
R5 and R6. Respondent number 5 and 6.
5 and 6. The learned counsel for the petitioner submits that she may be granted 2 weeks' time
yes, my lord.
to file rejoinder affidavit. Fair allowed, this is a list the matter after 2 weeks.
Item number 3.
Please, Your Lordship. My lord, my opponent is not here. Counsel for the state respondents are not here, my lord. She may be on leg.
Okay, after some time.
Yes, my lord.
Item number 4.
My lord, the respondents have filed their affidavit, and if I may be given time to go through their affidavit in opposition and file a reply if required, my lord.
Okay. Heard Miss,
Violet Hamwani.
learned counsel for the petitioner and Ms. Pembuel for the state respondent. The learned counsel for the petitioner submits that the respondents herein have filed their counter affidavit and she may be granted some time to go through the same and also to file rejoinder affidavit if necessary. Fair allowed, recessal is the matter after 2 weeks.
My lord.
After 2 weeks.
Obliged.
Item number 5.
Matter may be kindly
So far for a while, the conducting council is on its way.
For time being?
Yes.
Time being.
Yes.
My lord, in this case, I have just filed affidavit on behalf of the private respondents. It's being filed as we speak this morning. And the state we have not filed yet.
You have received the copy?
Yes, my lord.
So then let it be fixed for admission hearing.
My lord, my senior would like to make some submission.
Okay, all right.
Item number 6.
Yes, Your Lordship, I'm representing the state respondent number 2 and 3 in this matter, and I'm seeking another 2 weeks' time to file my affidavit.
My lord, similar prayer for respondent number 1.
Affidavit. Okay. Heard, miss. Your name, please? Learned counsel for the petitioner. Then Madam Government Advocate for the respondent number
Number 2 and 3.
2 and 3. And learned CCC.
Oh yes, for respondent number 1.
Respondent number 1 and Mr. Learned counsel for the respondent number 5 and 6. The learned counsel for the respondent number 1, 2 and 3 submits that they may be granted 2 weeks time to file counter affidavit. Parallel, rest shall list the matter after 2 weeks.
Obliged.
Item number 7.
My lord, I am for respondent number 1 to 4. I'm seeking 3 weeks' time for filing my affidavit, my lord.
Heard, Mr.
Yes, my lordship.
Learned counsel for the petitioner and Ms. So-and-so learned CCC.
Yes, my lord.
CCC.
For respondent number 1 to 4.
So respondent number 1 to 4 and she pressed for granting her 3 weeks time to file counter affidavit. Parallel, list the matter after 3 weeks.
Obliged.
Obliged.
Item number 8.
Yes, Your Lordship, even in this matter, I'm representing the respondent number 5, 1 to 5, and I'm seeking another 2 weeks' time to file my affidavit.
My lord, as for the respondent number 6, 7 and 8, I have taken steps upon them as per the direction of this honorable court on 29th May. And as per the office note, my lord, the postal receipt were received on 2nd of June from the respondent number 6, 7 and 8. An ID card has already returned back from respondent number 7. Respondent number 6 is the Kala of Aizawl district. Respondent number 7 is NHIDCL, and respondent number 8 is the private respondent, the rival party. In this case, my lord,
So notice was served upon respondent number 7.
7 ID card returned back from respondent number
Yes,
7. So
but in
far.
respect of 6 and 8, ID card yet to be returned.
Yes, my lord.
Okay, we will await then.
My lord, I have an interim prayer as notice was also issued on the last occasion on the interim prayer, my lord. The issue pertains to two village councils regarding their boundary dispute, two village council boundary dispute. And there is an committee which is considering the dispute of the two village border boundary. In spite of that, my lord, on the other hand, there's a project of construction of 4-laning on the said disputed area. And while the matter is sub judice under the committee of boundary dispute, another committee was constituted by the road construction under the name of Empowered Committee of Road Construction, wherein they have held that the boundary dispute is beyond their purview. That is correct. But in spite of that, they have made a decision to pursue with the land acquisition proceeding over the disputed area. Meaning thereby, if they proceed with the land acquisition proceeding, the petitioners would be suffering irreparable loss and hardship. So my interim prayer these days is, my Lord, let the Kala, the director not to proceed with the land acquisition proceeding only over the
No,
disputed
maybe
area.
you say these are infrastructure project. There are some provision in the specific relief act in respect of this infrastructure project. Interim order, generally stay should not be granted or injunction should not be granted.
But my Lord, the boundary dispute between these two rival parties were under consideration.
Maybe you settle it.
That is in the under the authority of the respondent officials.
What is the specific relief act?
Otherwise, my Lord, if I may be allowed to take steps upon the Kala respondent number 6 by way of Dasti, it's in Aizol only.
6 or 7?
6, my Lord. 7, they have received the
Kala is respondent number 6.
Kala is respondent number 6. I may be allowed to take steps by way of Dasti upon this Kala respondent 6 as well as 8, 6 and 8.
Heard Mr. Ralte, learned counsel for the petitioner, and Madam so-and-so, learned government advocate for the respondent number 1 to 5.
Yes, Your Lordship, 1 to 5.
Office note dated 23rd of June 2026 indicates that neither AD card nor service report in respect of respondent number 6 and 8 received till date. The learned counsel for the petitioner submits that he may be allowed to effect service upon respondent number 6 and 8 by Dustimut. They are allowed after effecting service upon respondent number 6 and 8 by Dustimut, the petitioner shall file an affidavit to that effect before this court. This is the matter after.
My Lord, this may be taken up again on next week, Friday, 3rd of July, before
3rd of
defecation.
July. Okay. This
3rd of July.
is the matter 3rd of July.
Item number 9.
You go through the
I
provision
understand,
of
my Lord.
My Lord, I'm the legal counsel for the petitioner in this case. As per the last court order, the state were directed to file affidavit, my Lord.
So, madam, you are for respondent number 224.
Yes, Your Lordship, this matter is handled by Miss Caroline. So she will be filing her affidavit during the course of the day.
Today.
Yes.
Okay. Heard Mr. So-and-so, learned counsel for the petitioner, and madam appearing on behalf of Miss
Caroline
learned
Lung Oi Puk.
government
Kailan
advocate,
Lung Oi Puk. Yes.
government advocate, and submits that she will be filing counter affidavit for the respondent number 2 and 4 during the course of the day. Office note dated 23rd June 2026 indicates that service report in respect of 6 and 7 are still awaited. You want to take fresh sir?
My
Or
Lord,
will await service report?
we'll wait.
Okay. List the matter after.
Yes, Your Lordship, one point, as per the instruction received by her, it seems that they have gone back to their respective
My Lord,
building.
On 10th of June, they have returned to their
They
home,
returned to their building.
with the help of the SP and the DC. Since initially they were evicted by the NGO on the ground that they were involved in selling liquor.
Thereafter,
They were
mean
executed by the
consummate liquor.
NGO, and now they were returned back to their respective home, Your Lordship, with the help of the respondent number 1 to 5.
Okay, you file your affidavit.
Yes, Your
please.
Lordship.
List the matter after 2 weeks. Awaiting
Yes,
service
yes,
report
yes, my
upon
lord.
respondent number 6 and 7.
It's obliged.
Item number 10.
Your Lordship, this is an application for impleadment of the petitioner as a respondent in the connected WPC number 128 of 2025. And the instructions from the Kala is still awaited, my lord.
My lord, Kala is not represented, my lord.
Represented.
Not yet represented, my lord.
Lordship, I'm appearing on behalf of my senior Caroline, who will be representing Kala, respondent number 7. Lordship, Lordship, we haven't received instructions from the Kala, so if we may be kindly, if the matter may be listed 2 weeks again.
2 weeks time.
After 2 weeks, my lord.
No, this application is for impleadment.
Yes, my lord. Impleadment,
Impleadment of?
impleadment of the present petitioner as a respondent in the connected writ petition, my lord. It's a simple matter, my lord. Just for impleadment.
So why instruction from Kala is required?
No, my lord, it's not as simple as my learned friend has submitted, my lord. There is some confusion and some issues involved, my lord. So this is the reason why, if we look at the Honorable Court's order, it can be seen that there is some issues to be resolved before impleading the instant applicant, my lord. So,
No, what is the issue involved in the impleadment?
my lord,
The question is whether any relief is being sought for against the person to be impleaded in this writ petition.
my lord, the facts of the case in the brief is that I was awarded a compensation under NH Act, my lord, for my land, which was acquired due to the widening of the NH 54, NH National Highway, my lord. So, my lord, and then the amount was not disbursed to me yet, and that is the reason why I'm filing the instant
No, that's all right.
WPC.
After impleadment,
And then
finally-
subsequently, my lord, subsequently, my learned friend had submitted the application for impleadment for that 3G which was awarded in my name, my lord. There is no question of overlapping. So,
No, whether that issue can be addressed in a application for impleadment.
That issue cannot be addressed. It has to be addressed in the main writ petition.
Yes. Why you are objecting?
my lord, I have submitted my grounds of objection.
So anyway, today we are not going to dispose of this IS since
Kala
Kala
is not represented,
Kala has not filed their, not received their instruction. Heard, mister? Yes, learned counsel for the applicant and Mr.
Benjamin Lathamona. Benjamin
Learned
Lathamona.
counsel for the opposite party number
Is it number
in the I
number one, my lord?
number 1 and Mr.
Jerry F. Elvin Fela,
Learned counsel for the opposite party number
respondent number 7, my lord.
7 between bracket Kala and madam for respondent number 3 and you respondent number 8 to 11. The learned counsel appearing for respondent number 7 between bracket Kala submits that he has not received any instruction and he prays for granting him some time to receive the instruction. They are allowed. List the matter when
2 weeks.
after 2 weeks.
Yes, my lord.
Then after vacation.
After vacation.
On
the
list
14th
the matter on when
14th of July.
14th of July. 14th.
Obliged, my lord.
Obliged.
Item 11.
May it please your Lordship. Lordship, this is a an application for continuation of 10 days, Lordship.
10 days.
10 days. And also, Lordship, as mentioned in our previous court date, Lordship, we have...
So the opposite parties are represented?
Yes, Lordship.
Okay. What is the ground?
Excuse me, Lordship. Lordship, the reason is that Lordship, first of all, it's due to some unavoidable circumstances.
Pardon?
Unavoidable circumstances, Lordship.
Unable?
Unavoidable circumstances.
Unavoidable circumstance, you explain it.
Yes, Lordship. So what happened was that, Lordship, when the order was passed on 15th of December 2025, Lordship, since they are living in a far-off area and in a village area, Lordship, in a very remote area, so they were unaware of this this appeal process.
No, they are represented by the council.
They
before the
are
court.
represented, Lordship. Yes, that is true, Lordship.
Then,
But Lordship, the counsels here are that what happened was this in this case, when they were trying to apply for this certified copies. So there are some instances where some court fees are not available or some cancel stamps are not available and some court staffs are not available in that particular days. So within this 10 days of Lordship, we tried our very best to obtain the certified copies, which is required for filing this appeal, Lordship. So during this process, Lordship, unfortunately, Lordship, 10 days had lapsed, Lordship.
okay. Yes, any objection?
Yes, my lord. My lord, yesterday only, we have received original Bakalatnama from my clients, and then all the documents which have been served upon her. And then we have filed our power yesterday, my lords, but my name has not been reflected in the cause list, my lords. But it's all, I think it's already in the file, original file, my lords. My lords, that my learned friend has submitted is just oral submission. There is nothing on record which, in the application, that the submission has not been included in his petition, my lords, in his application. My lords, the only explanation which he has provided is in the application, condonation application at page number 3. That is para number 5. If I may read, your lordship, that the delay occurred due to the unavoidable circumstances while arranging the certified copy of the judgment, preparing the appeal papers, and obtaining necessary legal consultation and instructions. That is the only explanation. My lords, while considering the condonation of the delay, the length of the day is immaterial. The thing which has to be considered is the grounds, the explanation, sufficient explanation, and the sufficient cause which has been put forth by the applicant, my lords. So the impugned judgment was pronounced on 15th of December 2025. And then the limitation starts from 16th of December 2025. So then the applicant...
No, when you have received the certified copy?
Lordship, we received it on...
17/3/2026. After the limitation expired, they have applied for it, and on the same day, it was provided to him. 17/3. On the 92nd day.
So now, Lordship, as we have mentioned here in paragraph number 5, Lordship, there were as we have mentioned here clearly, that Lordship, there were some time required for preparing the appeal memo, Lordship, and we had to obtain some legal instructions from the as you call here, the appellant as well, Lordship. So without any instruction, we cannot have filed the appeal memo properly, Lordship. So that is the reason which we have mentioned here as well, Lordship.
My lords, from the starting point of the limitations, for when the limitation starts, during the month, day-to-day explanation may not be required, but during the month of December, from 16th of December to 31 December, what has he done? there is no explanation. And in the month of January 1st to January 31st, what has he done? No explanation. And during the month of February, no explanation. And during the month of March, 1st March to 15 March, the limitation expired on 15 March 2026. There is no explanation at all. And on the next day, that is 16th of March 2026, there is no explanation. And the applicant is still inactive all those periods, all those 91 days. He sleeps over, my lords. He's inactive. And then on the next day, on 17th of March 2026, he woke up from his bed and take action, applied for certified 2 copy and supplied to him on the same date, my lords.
No, you say, where this Bliss Council is situated?
It's situated in Chongte, Lordship, Longklai district. It's a very rural area, Lordship.
Rural area. What is the
it takes
distance from
around, like,
Maizam?
Lordship, I would say, if I'm not mistaken, around 12 hours. In this present condition, it could take more, Lordship.
12 hours.
It could, if I'm not mistaken, Lordship.
But my lords, the co-counsel is also practiced here. He who is representing in the district council court, my lords. I have one.
Delay is only for 10 days. Let us condemn the same. We will hear the.
My lords, I have one citation to submit, my lords.
No, those citations are always there. But whether that can be applied to the given facts and circumstances of this case has to be examined. Admittedly, they are living in a far-flung area.
Yes, exactly, my lords. There is one thing that has been done by the applicant is that, my lords. So after the appeal was filed, execution was already disposed after 90 days. Execution was filed. So that this is a delay tactics what have been applied by the applicant.
Also, Lordship, when the execution petition was filed, Lordship, in fact, we informed, it was during the pendency of this condonation of delay, Lordship. And in fact, we had to represent the client, and we even requested the court for appearing to virtual. And I even have the application here as well, Lordship, and it was granted by the Nana District Council Court. However, Lordship, when we tried to do a video conference, there was immense network issues, connection issues, Lordship. So it could not be possible. Ultimately, we had to make it through phone call, Lordship. And as a result, it is even reflected in the order dated 11th of June 2026, Lordship. The name of the councils are also represented. It has been reflected as well, Lordship. And that is a situation, Lordship.
Okay, let us condone the delay. Then admit the appeal. Then finally dispose of the same.
Also, Lordship, if I may make a mention as well that, Lord, in a previous court date, we have made a mention that there is an urgency in staying the order of 11th June 2026 is because, Lordship, I have also submitted the order, I believe, Lordship. If not, I also have it here. Lordship, as per the order.
No, first we have to condone the delay.
I understand, Lordship, but through this order, Lordship, his salary from the amount has to be deducted from his salary, Lordship. Whereas, although the amount is 5 lakhs, Lordship, the main disputed amount is only 2 lakhs. And the rate of interest is 10% per month, Lordship, which amounts to 120% per annum. And out of the 2 lakhs, Lordship, the appellant herein has also given back 50,000 rupees to the respondent herein, Lordship. So such is the dispute, Lordship. If such is a dispute, Lordship, then if the District Council Court passing an order of 5 lakhs to be deducted from his account, from his monthly salary, who is an ex-MDC, Lordship, a pensioner, Lordship. So he's earning a pension of a mere 40,000 rupees per month. And if an amount of rupees 30,000 rupees is deducted from his account monthly for 16 months and 20,000 rupees for 17 months, Lordship, then it would prove huge hardship.
Okay. We are not hearing the petition on merit, appeal on merit.
Yes, Lordship.
Heard, Mr.
Samuel Patswal.
Learned counsel for the applicant, and Mr.
Yes, Vanlalfriata.
Learned counsel for the opposite parties. This application under Section 5 of the Limitation Act is papered by the applicant for condemnation of delay of 10 days in preferring connected appeal against the judgment dated 15/12/2025 passed by the District Council Court, Sakma Autonomous District Council. The learned counsel for the applicant submits that the applicants herein are living in a far-flung area and that the certified copy of the impugned judgment could not be obtained in time, and there was also delay in obtaining legal opinion and also in preparation of the memo of appeal, and as such the appeal could not be filed within the stipulated period of 90 days, and there is delay of 10 days, and the same is not intentional, rather it is circumstantial, and he has a good case to be heard and disposed of on merit, and under such circumstances he has contended to allow this application. The learned counsel for the opposite parties, however, vehemently oppose the petition. He submits that the delay has not been properly explained, and what is submitted by the learned counsel for the applicant is not incorporated in the application itself. And under such circumstances, he has contended to dismiss this application, and he also apprised this court that execution proceeding has already been initiated against the applicant herein. This court has carefully considered the submission of learned counsel for both the parties and also carefully gone through the explanation put forwarded in the application and also the documents placed on record. It appears that in paragraph number 5 of the application, the applicant has stated that the delay occurred due to unavoidable circumstances while arranging the certified copy of the judgment, preparing the appeal papers and obtaining necessary legal consultation and instruction. And it also appears that the delay is not intentional, rather it appears to be a bona fide one, and the same is then sufficiently explained in paragraph number 5 of the application, and therefore this court is inclined to allow this application by condoning the delay of 10 days in preparing the connected appeal. In view of the order passed in this interlocutory application, now the registrar shall register the appeal and list the same before the court on next Monday.
Yes, Lordship.
Monday.
Much obliged.
Deeply obliged.
Pass over item number 5.
Lordship, by an order dated 18/6/2026, Lordship has had directed that the matter be heard today on 25/6/2026, and the learned Additional Advocate General was directed to file the affidavit in opposition and furnish a copy to me. But till date, no such affidavit has been filed. Lordship, in the meantime, the first notice was issued on 6/11/2025, and now more than 6 months have elapsed. Now, the first order has indicated that the interim matter will be heard on the next date. on the next day. That is after 1 month. And in spite of that, Your Lordship, much time has elapsed, and till date, no such affidavit has been filed. Your Lordship, the matter in this connection is regarding an issue whether the private respondents number 6 to 36 can or should be allowed to supersede the petitioners, and whether the private respondents number 6 to 36 who were appointed on coterminous basis as MR health worker under respondents number 1 to 4 can be categorized as employees under CSS. And even if they are employees under CSS, that is Central Sponsor Scheme, that is monitored by the respondent numbers 5, the director of NHM. These private respondents were never monitored or administered by the respondent number 5 at any point of time. They were directly taken by the department, and they are under the state government. And Your Lordship, there are two schemes. The scheme of 2020 at page 110. Page 110, Your Lordship. This is a scheme known as the Government of Mizoram Regularization of Provisional Employees Scheme 2020. As part of this scheme, at clause 2 clause 2, subclause 2, it provides, this scheme shall not apply to the following class of provisional employees under Government of Mizoram. Provisional employees engaged on coterminous basis. Provisional employees engaged under centrally sponsored schemes, or provisional employees engaged against any scheme-borne post. So the private respondents had sought for their regularization under this scheme, and they were not allowed by the state government. And it had stated at page 124, Your Lordship, there's a ID number so dated 9/7/2024.
Today you are pressing for the interim.
Interim, yes.
Your interim relief is staying the operation of the office order dated 21st of August 2025.
Your Lordship.
So where is that order?
The order is at page 133, Your Lordship.
133.
Annexure 21. This office order is based on the recommendation made by the selection committee, Departmental Promotion Committee, at page 130. 130, minutes of the DPC to consider regularization of 31 health workers, provisional employees, held in the office chamber of the Commissioner and Secretary, Health and Family Welfare Department on 15/7/2025. These are the 31 health workers who were employed under coterminous basis, and on the recommendation of the DPC, as part of his order, at page 133, this mentioned 31 health workers are hereby regularized as per Government of Mizoram regularization of centrally sponsored scheme, CSS employee scheme 2024. Lordship, the contention of the petitioners is that this respondents number 6 to 33, 6 to 36, they were never part of the scheme. They were not employees under CSS. Lordship, there is another scheme at page 82. May I take a lordship to
Yes.
the scheme, which is dated 18 June 2024. It is known as the Government of Mizoram Regularization of Centrally Sponsored Scheme Employees Scheme 2024. These employees under CSS, they did not have any provision for their regularization. Even if they continued for more than 10 years, even 20 years, they cannot be regularized because those schemes under the state government, it has been specifically stated that these CSS employees are not included in this particular scheme. So if one is under CSS employment, he cannot come under a regularization scheme of the state. But since there are a number of health workers, Your Lordship, I take a lordship to page 70. Page 70 is a letter dated 26 August 2025, furnishing documents under RTI Act 2005, and here health worker list under NHM. Those health workers who were appointed right from 2007 to 2023, 2007 to 23. There are presently 354 health workers who are waiting for their regularization under the new scheme, that is of the scheme of 2024. And the first engagement of the private respondents was in 2014, while the petitioners and many other health workers were initially engaged as such with effect from 2007. The petitioners are only a few amongst those health workers In fact, they're espousing the cause of their other friends also. In fact, even counting the number of those who are recruited or engaged in the year 2007, if your Lordship turns to page 74, the list continues till 135, 136. 136 is the last engagement, the last employee who was engaged in 2007. At the same time, Your Lordship will see there are certain other, number of others who were appointed prior to 2014. 2014, if we take the figure till 2014, it comes to 293 at page 77. So this is the list of health workers engaged under CSS in waiting. They have been waiting for their regularization under this particular scheme of 2024. Now, the respondents, the private respondents who were initially engaged in the year 2014, they have been given undue advantage over the petitioners and those of the seniors who have been waiting for their regularization under the given scheme, that is of 2024.
You have been working since
Since 2007.
2007,
Yes, Your Lordship.
and the persons appointed in the year 2014 have been
2014.
regularized.
Yes, they are sought to be regularized and they are now regularized. 2014 is the date when they were appointed. If I take Lordship 2,
Why the petitioners are left out then?
Your Lordship, they are left out for reasons best known to the state respondents. Your Lordship, the manner in which the matter has been taken up by the state, it is very difficult to understand. Because initially they were shown as employees under the state government on MR basis, on coterminous basis. Coterminous basis, Your Lordship, as a coterminous employee, they are not entitled or eligible for regularization under any of the schemes. And there was an application from the department concerned, which I have read out, Your Lordship, at page 124. At page 124, Annexure 17. This is ID number so dated 9/7/2024. There is a proposal from the Health and Family Welfare Department for deletion of the term coterminous from the initial engagement of 38 health workers, male and female. But that has been regretted by the Finance Department, and the Finance Department sticks to its earlier decision conveyed White number so dated 23/2024. And there is advice given to them. However, the department is advised to go for Government of Mizoram regularization of centrally sponsored scheme, employee scheme 2024, notified by the government on 18/6/2024 for regularization of the 38 health workers in question. They had given the advice which is legally wrong. Legally wrong means, Lordship, they are not eligible even for the regularization under the CSS Employees Regularization Scheme of 2024. Because they are not CSS employees. What they have claimed is that they are drawing their pay under CSS head, but that does not make them CSS employees. If I take a Lordship to page 94. Page 94, Annexure 11. This is the employment, the engagement of the private respondents. The 94A is the type copy, Your Lordship, it's clearer. May I read, Your Lordship? In pursuance of the recommendation of DPC meeting held on 23rd and 24th September 2014 in the office chamber of Principal Director, Health and Family Welfare Department, the persons listed in annexure are hereby engaged to the post of health worker, male and female, under Directorate of Health Services on MR Skill 2 basis, with effect from the date of joining to this directorate up to 28th February 2015, and posted at the places shown against their names. They'll be given a fixed remuneration of ₹10 per day, subject to production of medical fitness certificate and police verification of character and antecedents. They are informed to submit joining report to Deputy Director, Directorate of Health Services, ISOL, on 31/10/2014 positively, which shall be treated as actual joining date to their respective posts. No joining report will be accepted after the expiry of this date, and they shall be deemed to deny the appointment. Further briefing on service matter of his work shall be delivered on the same date from 11 to 2 p.m. at the Conference Hall of Directorate Health Services, for which attendance is compulsory. The appointment is purely coterminous. Your Lordship, this is very important. The appointment is purely coterminous with the scheme of family welfare and shall not bestow upon them the right to claim for regular appointment, and they may be terminated from the service for unsatisfactory performance and misconduct, even before the expiry of their contract period. The entertainment are made against a vacant post with the approval of government by DPNAR, ID number so-and-so, finance, ID number so-and-so, dated 25/7/2014, and dated so-and-so. So, Your Lordship, all this would indicate that the posts to which the private respondents were appointed or engaged by this engagement order dated 21/10/2014 pertain to the state posts which are not created under CSS. These are posts which are created under the state government itself. So they were appointed as such, but on coterminous basis. And coterminous with the scheme of family welfare. Scheme of family welfare continues even till today. So they continue to function as such. So that does not mean that they can be regularized under the state scheme or under the scheme for regularization of CSS employees, because they continue to be coterminous. And the names of those employees are here in the following pages till 99A. So they have been working as such from 2014 for a little more than 10 years. While the petitioners have been waiting for the regularization, they were not given any opportunity of being regularized because there was no scheme for regularization of CSS employees earlier, prior to implementation of the 2024 regularization of CSS employee scheme by the state government. But when the state government had formulated and enforced this 2024 regularization of CSS employees under the state government, the private respondents were given priority only because their attempt for regularization under the state scheme that failed, and since they were given a wrong advice by the finance department that you go for regularization under the Mizoram regularization of centrally sponsored scheme, CSS employee scheme to 2024, notified by the government. So this is the wrong advice. And on the basis of this, the matter has been taken up for regularization of the 38 employees. Your Lordship, what follows, the finance department ID letter is at page 125. 125, Annexure 18. There's a letter dated 15 July 2024. It says, it is a letter addressed to the Principal Director, Health and Family Welfare Department on the subject of proposal for deletion of the term coterminous in respect of provisional employees, health worker, male and female, regarding reference is given. With reference to a proposal for deletion of the term coterminous in respect of provisional employees, health worker, male and female, white letter numbers and date cited above, I'm directed to reproduce decision of Finance Department as follows. So, the proposal of Health and Family Welfare Department for deletion of the term coterminous from initial engagement of 38 health workers, male and female, is regretted as Finance Department sticks to its earlier decision conveyed white ID number so and so. However, the department is advised to go for the Government of Mizoram regularization of centrally sponsored scheme, employee scheme 2024, notified by the government, white so and so, for regularization of the 38 health workers in question. This is issued in line with Finance Department, white ID number so and so, dated 9/7/2024. It has a reference to the pre-page. So thereafter, Lordship, there's an approval for extension of engagement in respect of the 46 contractual employees and 46 numbers of provisional employees under health services. So those who were engaged and who have been engaged under CSS, they were never given the designation or the status of PE. PE is something higher than the master role. Master role status was improved by the state government and they were elevated to the status of PE, that is provisional employee. Earlier, they were appointed as MR Skill 2, but subsequently they were designated as PE without the skill. Whether skill 1 or skill 2, that's not mentioned. Now they have been designated as PE. Now, when they are PE, they have been classified as something different from those of the CSS employees. So, Lordship, my humble submission is that in view of the latent and patent defects and the actions taken for regularization of the private respondents on the basis of this impugned office order, Lordship, a wrong has been committed against the petitioners. So if the state government wants to prolong the date for filing of their affidavit, let them prolong, but let something be done. Let something be done by way of an interim measure.
No, they have filed their affidavit.
That is the respondents number 6 to 36. That is private respondents. They have filed it. But they are only the beneficiaries of the illegal action of the state. What we have to see is what will the state government say in respect of all these things.
No, state government has filed affidavit.
No, state government has not filed. It is only in respect of the private respondents. That,
the mission director, respondent number 5.
Or mission director, respondent number 5 has also filed, yes. But mission director is not authority for appointment of those respondents.
Private
3 to
respondents.
6. Yes, 3 to 36, 6 to 36. Mission director is directly taking care of the CSS employees.
Okay.
So in view of the patent illegality committed by the state in making or regularizing the services of the private respondents, that too much before their due date. Due date in the sense, if they are considered to be CSS employees, let them wait for their turn. While a number of their seniors are waiting, who were appointed in the year 2007, 8, 9, 10, 11, 13, and 14 they were appointed. Now, unless and until all those who were appointed prior to the private respondents were given
No,
regularization.
the question is whether the private respondents are appointed under the same scheme?
Yes, yes.
Same scheme.
Same scheme.
Okay.
If so, whether they have a right to, supersede the petitioners who are senior to them in seniority in their engagement
Okay.
as
Okay.
health workers.
Yes, madam, what is your stand? Your affidavit is yet to be
It's in
filed.
respect of the private respondents. The government affidavit is on its way, my lord. It will be prepared by, most probably by next week, we'll receive it from the department concerned.
No, that's all right, but what is your stand?
Yes, my lord. Our stand is that, my lord, there are two sets of employees, as your lordship knows. One is under the state government, where the salaries, everything is paid by the government itself. And the other is a centrally sponsored employees, where my lord, it's under a scheme, for a
No,
certain period of
no,
time.
first you tell me whether the petitioners and the private respondents are appointed under the same scheme?
My lord, it's under lordship, I have filed my affidavit this morning, but I think it has not reached yet. It has, it's under a scheme, my lord, under a centrally
No,
sponsored
no,
scheme.
under the same scheme.
That I'll have to get instructions on that, my lord.
No, no, you have already received instruction and you have filed your affidavit.
My lord, whether it's under a centrally sponsored scheme, that much I'm sure, but
Both are,
both, yes.
the
my lord.
petitioners
The
and
petitioners
the
as
private
well as the private
respondents are
respondents.
appointed under the centrally
Centrally
sponsored scheme.
schemes. That is true.
That is true.
That much, yes, ma'am.
Then why the claim of the petitioners are ignored?
My lord, your lordship will see, come to page 82 of the writ petition. This is the scheme for regularization of CSS employees. And here, my lord.
2024.
Yes, 2024.
Yes,
And
whether
they
the petitioners are not come under that
They
that
should
scheme?
come under this, but there's a checklist at page
Pardon?
85. Checklist,
Checklist.
yes, at page 85, my lord. Page 85 of the petition. This is done to ensure that the appointment is not illegal, madam. At page 85, this is the office memorandum. Checklist for submission of proposals in connection with the Government of Mizoram regularization of centrally sponsored scheme, employee scheme 2024. The Government of Mizoram regularization of centrally sponsored scheme, employee scheme 2024 was notified by so dated 18 June 2024. In order to avoid undue delay in according approval to the proposals for regularization of CSS employees under this scheme, all administrative departments and head of department must ensure that the proposals contain the following details and documents. There are some number of documents which are required to be submitted. Number one, the number of posts proposed to be filled by regularization as per the scheme. Post to which regularization is proposed must be clearly identified. And number two is copy of the centrally sponsored scheme guidelines. And number three, copy of advertisement to determine whether proper recruitment procedures were followed by the recruiting agency at the time of initial engagement. And number four, copy of constitution of approved DPC that the recommended appointment engagement of the CCS employees. And number five, copy of the DPC meeting minutes recommending appointment engagement under the scheme. And number six, copy of initial engagement appointment order. These are all the lists they have to submit for regularization, so that it is made sure that
No,
the appointment is not illegal.
is it your case that the petitioners have not complied with this checklist?
Yes, my lord. The checklist 3, 4, and 5, they could not comply.
3, 4, and 5.
3, 4, and 5. In fact, the private respondents, they could comply with all these checklists. That is why they have been regularized. 3, 4, and 5, my lord, they were taken without any advertisement, first of all. That is backdoor entry, which has been held by in several Supreme Court citations, my lord, to be illegal appointment. And there is no advertisement and no DPC as such. So they are not eligible for regularization as per the office memorandum. So, my lord, like I've submitted, there are many CSS employees. They have been employed since when we don't remember. And so many are done through backdoor entries. There is no advertisement. There is no DPC. Nothing is there, my lord. They have just been pick and choose. It's a pick and choose
No,
policy.
maybe so they are working since 2007.
2007.
So why you are extending them if they are
My lord-
illegal appointee? Why
Yeah.
you are allowing them to continue with the job till today?
Because it's a sponsored scheme, my lord. We are availing
Maybe.
the benefit of the central scheme. But to regularize them, it's not the duty of the
No,
government.
whether in the CSS centrally sponsored scheme there is provision for advertisement that employees should be taken after due selection process and after proper advertisement. Is there any requirement in the centrally sponsored schemes?
My lord, I'm not sure about the scheme, but that has to be followed by the government if an employment is to be made, my lord. That has to be followed because we need competition. Advertisement should be there. It cannot be a
that's all
backdoor
right, but
entry.
whether at the relevant point of time it was followed or not, and whether there is any requirement in the centrally sponsored scheme that there should be advertisement, there should be proper selection process, and only thereafter they will be appointed.
My lord, in the
Is there
centrally
any
sponsored
requirement?
scheme, no such requirement is
Then
mentioned.
how can you now contend
But
that
for
that there
regularization-
was no advertisement?
For regularization, we need a proper channel, madam,
Hmm?
which has to be done through a proper channel.
No,
We have to
that's all
make
right.
sure
If
that the
at the relevant point, at the time of their appointment, that scheme was, that provision was not there, then
My lord, that I'll have to inquire if it's there or not, my lord.
you have to inquiry.
Yes, my lord. I'm not sure whether it's there or not. It may be there also, my lord. I'm not sure. I cannot say.
Lordship, if I'm allowed, the appointment orders of the petitioners will indicate that appointment orders were made on the basis of recommendations made by the DPC. DPC had screened those petitioners and they were given appointment. And
Before appointment?
Yes. In 2007.
There was a screening?
Yes. Screening committee was there, DPC. And perusal of the recommendation made in favor of the private respondents did not indicate that they have gone through all such tests as required under the checklist. Now, the checklist, which has been appended to the 2024 scheme, regularization scheme.
You have served notice upon the private respondents?
Yes, yes.
They're unrepresented.
Yes, my lord. I'm representing all the private respondents as well.
You are representing?
She is representing.
Okay, you are representing.
And Your Lordship, this proposal, the minutes of the meeting at page 130 simply indicates the department placed before the DPC 31 numbers of eligible candidates of health workers, provisional employees. After careful scrutiny of all the relevant documents and on the basis of their performance reports for the last 5 years, DPC recommended the following eligible candidates for regularization of their services to the post of health workers. Now, nothing is stated about the checklist. Now, they're saying the learned counsel for the private respondents have stated that the petitioners could not pass through the checklist 1, 2, and 3. Now, this is not a case. It is a clear case of favoritism. It's not a case that we could not pass through the checklist.
Okay, let us state the order.
Right, Your Lordship.
My lord, let the state at least file the affidavit, my lord, in that regard.
Pardon?
For stay, my lord, let the state at least file the affidavit, my lord. It's
No, you have already filed the affidavit.
it's for the private respondents, my lord. The state has made out a clear case, my lord. I'm sure I'll be receiving it by next week at least, my lord.
6 months have elapsed. They have
The
taken
problem is, my
more
lord,
than
there are
sufficient
2-3
time.
departments involved, and they have to make a consolidated
No,
paragraph.
that's all right, but it appears that there is a prima facie case in favor of the applicant, or in favor of the petitioners.
My lord,
They are senior to the private respondents.
they are senior, but the mode of recruitment is itself illegal, my lord.
Illegal.
This is not allowed by several judgments of
No,
the Supreme Court.
madam, you see, as of now, there is no document to show that their appointments were illegal. They were
So, my
selected
lord,
on the
let me at
basis of
least get instruction on
pick and
whether
choose policy.
advertisement was required for any CCS employees, my lord. At least instruction on that. If it's required, then it's purely illegal.
Okay, let us pass one interim order today.
My lord,
If you file the affidavit, if necessary, then
till
we will
at least,
vacate
my
the
lord, the
same.
interim order till the next returnable date.
Pardon?
Till the next returnable date.
Yes,
All right. The interim order.
yes.
Lordship, they can apply for modification or vacation.
Yes.
So
No, no,
required.
that question does not arise.
Yes.
Because this court has heard her.
All right, right, yes.
Only in case of an interim
Yes,
pair,
Your
that
Lordship.
would have been the matter. Heard, Mr. Lalaram Joba, learned senior counsel assisted by Mr. So learned counsel for the petitioner, and Ms. Pemwell, learned government advocate, learned additional advocate general for the
Lordship,
respondent number.
she's appearing in, she's appearing as on behalf of both. Oh, all right.
For respondent number
Private is 6
1
to
to 4,
36.
1 to 4, as well as 6 to 36.
1 to 4 as well as 6 to
36.
36. In this petition under Article 226 of the Constitution of India, the petitioners have challenged the order challenge the recommendation made by the DPC in its meeting held on 15/7/2025 for regularization of the private respondent number 6 to 36 to the post of health worker, and also challenge the office order dated 21/8/2025 by which the recommendation of DPC was acted upon and the service of the said respondents have been regularized under the 2024 scheme. And also to issue direction to the state respondents to regularize the service of the petitioners who are senior to the private respondent. against the vacant post of health workers under the state government with a retrospective effect from the date of the respondent number 6 to 36 were regularized. That is 21st of August 2025 with all service benefit. The learned senior counsel for the petitioners submits that the petitioners were appointed in the year 2007, and since then they are waiting for their regularization of service, but void impugn DPC minutes of the meeting dated 15/7/2025. The state respondents have recommended for regularization of the respondent number 6 to 38 to the post of health worker, and thereafter by order dated 21st of August 2025, the said minutes of the meetings were acted upon and the service of the private respondents were regularized under the 2024 scheme. Mr. Swenso, learned counsel for the petitioners, further pointed it out that the state respondents have adopted pick and choose policy in regularization of service, and the benefit of the scheme of 2024 is arbitrarily denied to the petitioners who are much senior to the private respondents, and under such circumstances he submits that a prima facie case for staying operation of the impugn order of regularization dated 21st of August 2025 is made out, and therefore he has contended to stay the same till disposal of the writ petition. Ms. Pembual, learned counsel, learned additional AG for the respondent number 1 to 5, and also the counsel for the respondent number 6 to 36 submits that the regularization of service is not automatic, and the same is done under the scheme of 2024, and there is a checklist prepared by the state respondents, and the same is at page number
85.
85.
85.
Which is enclosed as annexure number 9 of the writ petition at page number 85, and of the said checklist, the petitioners herein has failed to comply with the requirement of clause 3, 4, and 5, for which regularization of their service could not be taken up by the DPC. And further, she submits that she has already filed an affidavit today morning, and the same has not been placed on record, and that she has also not filed the affidavit in respect of the private respondent.
No,
and on such grounds, she has contended that a week time may be granted to file the affidavit on behalf of the private respondent.
state respondents.
State respondents. However, Mr. Lalrim Zohaba, learned senior counsel for the petitioner, submits that since the service of notice, the state respondents have received more than
6 months.
More than 6 months time to file their response, but they fail to file their response, and therefore there is a requirement of staying operation of the impugn notification regularizing the service of the petitioners. No, respondents number 6 to 36. It is to be noted here that during the course of hearing, the learned additional advocate general was asked as to whether there is a requirement of publishing advertisement and following recruitment procedure in respect of the appointment being made under the centrally sponsored scheme. The learned additional PP submits that she has to obtain instruction in that regard. But she has a no, but to another query of the court, she has replied that the petitioners herein were appointed in the year 2007, but without following any without following any procedure, and their appointments were illegal and arbitrary, for which their case could not be considered for regularization. Having heard the submission of learned counsel for both the parties, this court has carefully gone through the petition and the documents placed on record, and indisputably the petitioners were appointed in the year 2007, and the private respondents were appointed in the year 2014. And also indisputably there is a scheme for regularization which was adopted in the year 2024, and though the learned additional PP has pointed it out that in view of the office memorandum dated October 2024, and the checklist how I start the word, start the line. Yet the submission of the learned additional AG that the petitioners herein failed to comply with the clause number 3, 4, and 5 of the said office memorandum left this court unimpressed. It appears that a prima facie case appears to be made out in favor of the petitioner, and accordingly, till returnable date, the impugned order dated so and so stands state. Place the matter after 1 week.
No, but the matter may be fixed after the vacation.
Vacation?
Yes. Staying the operation of the impugned order for 1 week, thereafter, Lordship, not only if the matter is to be stayed at all, Lordship, it needs to be stayed till final disposal of this writ petition.
No, we'll consider it as a letter file
Several
affidavit.
queries were made, so I'll get instructions on that.
After filing of the affidavit.
Okay, after vacation then. On recessal is the matter on 14th of July. 14th of July.
Yes.
Any other matter?
Pass over item. Item number 3.
My lord, it seems the learned counsel for the state respondents is not available today. So not available today. The matter may be taken up on next Tuesday, my lord. That is
Tuesday.
23.
Okay. Heard, Mr.
That'll be a no namte, my lord.
Learned counsel for the petitioner.
For respondent number 1.
And Madam, for the respondent number 1. The learned counsel for the petitioner submits that the matter may be listed on next
23.
Tuesday.
Next Tuesday, my lord.
We are allowed to list the matter on next Tuesday.
No, my lord. Next
20
Tuesday is holiday. That at least 2nd of July, my lord. Thursday. Next Tuesday is holiday.
Holiday, yes. 2nd of July.
Yes, my lord.
Okay, Thursday. Thursday.
Lies, my lord.
Part 2 hearing. Item number 16.
None appears for the petitioner on call. None appears for the respondents also on call. List the matter after vacation. In the event of subsequent non-representation, appropriate order shall. Over.